School Highlights Chapter 1. Farming. Many licensees will concentrate on one type or style of property or on one particular neighborhood, a practice called farming, areas expert knowledge required for all real estate licenses. Property transfer licenses must possess the necessary expertise when writing contracts so that the property and attached rights can be successfully conveyed from one owner to another. Valuation and market conditions. No two properties are exactly alike. Licensees must be able to discern property differences and apply that knowledge to value. Marketing. Supply and demand are always changing. Licensees must know how to market properties efficiently. Government regulation. Local government, planning, zoning, real estate taxes, building moratoriums, and health codes. Tract building. Developers utilizing model homes to make sales from. School Highlights Chapter 2. Memory device, A-bar sale. The most common services of real estate are appraising, buying, auctioning, renting, selling, advertising, leasing, exchanging. Broker applicants must complete all broker pre-license requirements to obtain an initial broker license. Actively licensed real estate sales associates from another state or nation who have been licensed for at least 24 months during the preceding 5 years. Broker associate. An applicant for a broker license may choose to continue employment in a sales associate capacity with a current employer subsequent to passing the state broker examination. If so, the applicant will be registered as a broker associate after passing the broker examination. A broker associate is qualified to receive a broker license but chooses instead to be employed under the direction, control, and management of an actively licensed broker or owner-developer. In this capacity, the broker associate acts as a sales associate, not as a broker. Should a broker associate become inactive, his or her license status will be changed to an inactive broker license. General qualifications for licensure. An applicant for a Florida real estate license is not required to be a resident of the state of Florida, or to be a citizen of the United States. Answering background questions requires the disclosure of any criminal convictions, including felony or misdemeanor convictions or pleas, other than minor traffic offenses, regardless of adjudication. Driving under the influence, DUI, is not a minor traffic offense, and must be disclosed. Application denial. If an application to take the state exam is denied by the department, the applicant will be notified in writing. The notification will identify the reasons for denial and advise the applicant that he or she has 21 days from the date of receipt to request a formal hearing before an administrative law judge. Employment by a broker. A sales associate or broker associate can only work for one broker at a time. Employment by an owner-developer. The owner-developer must register with the department but does not receive real estate license. Sales associate. First renewal. The license of a sales associate who fails to complete this requirement will become void and the licensee will be out of business. If the licensee wishes to continue in the real estate profession, he or she is required to take the 63-hour pre-license course again and pass another state examination. Continuing education. If the CE requirement is not met within the renewal deadline, the licensee's license status will be changed to involuntary inactive. Individuals who are exempt licensure. Atemies in fact are persons who are granted authority under a power of attorney to act for others in some capacity, such as signing documents. Salaried employees of individuals, partnerships, or corporations who own real estate may perform real estate services on behalf of their employers without being licensed. School Highlights Chapter 3. Powers of the Department. The Department does not have the authority to issue injunctions against unlicensed persons, but may seek an injunction from the court for failure to follow a department order. Executive powers. Executive power can be exercised by the chairperson acting alone or can be delegated by quorum vote to any other commission member. Disciplinary authority of the commission may receive one of the following disciplinary actions: be issued a reprimand or an administrative fine up to $5,000 per offense, be placed on probation, or have their license suspended for up to 10 years or permanently revoked. First renewal, null and void. Involuntary inactive. A license may remain in an involuntary inactive status for no more than 2 years. Void and ineffective licenses. If a broker's license is suspended, revoked, or otherwise void, ineffective, the licenses of all persons who are employed under such broker become inactive. If a licensee decides to no longer practice real estate, they could return the license to the department. The license would be cancelled. Group license. A group license is a single real estate license that can be obtained if the sales associate or broker associate works for one owner-developer with affiliated organizations. Multiple licenses. A broker can be issued additional licenses in 2 or more capacities by requesting multiple licenses. The broker must show that the additional licenses are necessary for legitimate business reasons. Multiple licenses are not available to sales associates or broker associates. School highlights. Chapter 4. Administrative law, rules. The Department of Business and Professional are examples of administrative agencies empowered by statutes. Special agent is authorized under agency law by the employer to perform a single act. Subagent. A sales associate is a general agent of the broker and automatically becomes a subagent of all the broker's principal. Single agent is a broker who represents, as a fiduciary, either the buyer or seller, but not both in the same transaction. Principal is the party with whom the real estate licensee has entered into a single agent relationship. Transaction broker is a broker who provides limited representation to a buyer, a seller or, both, in a real estate transaction, but does not represent either in a fiduciary capacity or as a single agent. Presenting offers. All offers to the employer including oral offers or offer made without a binder deposit. Transaction broker provide limited confidentiality, motivation. Single agent. An agency relationship is created when a broker accepts employment under a single agency agreement. A broker may represent a seller or a buyer, or a landlord or tenant. Any attempt to represent both parties in a transaction would create an illegal dual agency. In a single agency relationship, the employer becomes the principal, who authorizes the broker as agent to perform certain services on his or her behalf. Summary of brokerage relationship duties. Residential sales. Duty: deal honestly and fairly. Non-representation, transaction broker, single agent. Duty: account for all funds. Non-representation, transaction broker, single agent. Duty: disclose all knows facts that affect the value of residential property. Non-representation, transaction broker, single agent. Duty: skill, care, and diligence, transaction broker, single agent. Duty: present all offers and counteroffers. Transaction broker, single agent. Duty: limited confidentiality. Transaction broker. Duty: additional agreed duties. Transaction broker. Duty: confidentiality. Single agent. Duty: obedience. Single agent. Duty: loyalty. Single agent. Duty: full disclosure. Single agent. Listing contract. When a broker is employed to find a purchaser, he or she is entitled to compensation when a ready, willing, and able buyer has met all of the seller's requirements. This is accomplished when the buyer makes an offer in accordance with the terms of the listing agreement, whether or not a sale is consummated. When employed to effect a sale, the broker is entitled to compensation upon consummation, the closing, of the contract. Referral fees. A Florida broker may pay a referral fee to, or share a commission with, a broker licensed or registered by another state or foreign country. A Florida broker may not pay compensation, fees, or share a commission with unlicensed individuals in exchange for soliciting or referring business. The sharing of brokerage compensation by a licensee with a party to the transaction with full disclosure to all interested parties is not considered a violation of F.S.475. School Highlights Chapter 5. Principal Office Requirements. The office must consist of at least one enclosed room in a building of stationary construction where negotiations and the closing of real estate transactions can be conducted with privacy. A principal office registration is transferable to a new location for the remainder of the current registration period. Branch office requirements. If a broker desires to conduct business from more than one office, each additional office must be registered individually as a branch office with the appropriate fee paid. If a broker closes a branch office, if a branch office is closed and then later reopened in the same location during the same 2-year license period, a reissue of the license may be requested, without the need to pay an additional fee. If a branch office is moved, a new application for registration and payment of the proper fee are required for the new location. Unless transactions are closed or sales associates are permanently assigned, a temporary shelter used by a broker as protection for sales associates and customers is not considered to be a branch office. Advertising. All real estate advertisements, including yard signs, newspaper ads, business cards, and/or any other advertisements must include the registered name or trade name of the brokerage firm. If a licensee includes his or her personal name in the ad, the licensee's last name must appear exactly as it is registered with the Commission. Internet advertising is any advertisement that is placed online. Internet ads must conform to the same requirement as printed material. The brokerage firm's name or trade name must be placed adjacent to, immediately above, or below the point of contact information. Blind ads is any real estate advertisement that does not contain the registered or trade name of the broker, or for which there is doubt that the ad is that of a real estate broker. If a licensee's personal name appears in the advertisement, the licensee must use his or her last name as registered with the Commission. Personal transactions. Brokers, sales associates, and broker are entitled to deal in real property for personal benefits. Licensees should make knows their own account and not acting on behalf of others. Licensees should make known their status as licensees to the public. This disclosure should take place prior to entering into serious negotiations, but is not required to take place in the preliminary stages of a transaction, such as newspaper advertising. Earnest money deposits. Post-dated checks are considered to be promissory notes and can be accepted as earnest money with the seller's approval. When a deposit is placed, with a title company or an attorney, the licensee who prepared or presented the sales contract shall indicate on that contract the name, address, and telephone number of the title company or attorney with whom the deposit was placed. Within 10 business days after each deposit is due under the sales contract, the licensee's broker shall make written request to the title company or attorney to provide written verification of receipt of the deposit. Escrow account. A broker is not required to be an escrow agent or to have an escrow account. An escrow account or trust account may be held in a commercial bank, title company which has trust powers, credit union, or savings and loan association located in the state of Florida. The escrow account cannot be held in a stock or bond brokerage house. A broker is not allowed to commingle or deposit the personal funds of any person with any funds being held in escrow, trust, or on condition. A broker is authorized to place and maintain up to $1,000 of personal or business funds in a sales escrow account, and up to $5,000 of personal or business funds in a property management escrow account for the purposes Depositing escrow funds. A sales associate or broker associate who receives an earnest money deposit on behalf of his or her employer must deliver the deposit to the employer no later than the end of the next business day following receipt. Saturdays, Sundays, and legal holidays are not considered business days. A broker immediately places the earnest money deposit in an escrow or trust account. Immediately is defined as no later than the end of the third business day following receipt. Escrow disputes. If a broker receives conflicting demands for escrowed funds, or the broker has good faith doubt as to which person is entitled to the escrowed property, the broker must give written notification to the Commission within 15 business days from the date of the last party's demand. Litigation, the broker would file a bill of interpleaded. Escrow disbursement exemptions. By rule, the Commission may establish the circumstances under which a broker may disburse funds from the escrow account without notifying the Commission or utilizing one of the escape procedures discussed above. The Commission has identified the following 3 exemptions. When a sales contract is subject to financing, and the broker is acting as an escrow agent, the broker may refund the deposit to the buyer without notification to the Commission if the financing cannot be obtained. Compensation. A sales associate can be paid any money due after his or her license becomes invalid for services performed while actively licensed. A sales associate who is not compensated as agreed upon by his or her employer may not file suit against anyone other than the employer. Change of employer or address. Any resident licensee who becomes a non-resident must notify the Commission of the change in residency within 60 days and comply with non-resident requirements. Sole proprietor broker. A sole proprietor can register and operate as a real estate broker if he or she has a current active and valid broker's license. General partnership. A partnership agreement can be expressed or implied, orally or in writing. No documents need to be filed with the state to create a partnership. Real estate brokerage partnership. Each partner who provides real estate services to the public either directly or indirectly must hold an active broker's license. Real estate brokerage limited partnership. A real estate brokerage limited partnership must be registered with the department. Joint venture. Joint venture is a temporary business that involves a single transaction or a predetermined number of transactions. Corporation for profit. The corporate name must include the word corporation, company, incorporated, or the abbreviation Corp Inc., or CO. The powers of the corporation are the activities in which the corporation is authorized to engage, such as lending money or brokering real estate. Real Estate Brokerage Corporation. The corporation and the names of all officers and directors of the corporation must be registered. At least one corporate officer must have an active real estate broker's license. A distinction should be made between a real estate corporation and a real estate brokerage corporation. A real estate corporation may buy and sell real estate for its own purposes, but may not provide real estate brokerage services. Chapter 6. Examples of second-degree misdemeanors include, but are not limited to, the following: disseminating false or misleading advertising. Felony of the third degree and are subject to criminal court proceedings, and punishable by a criminal fine of up to $5,000 and or imprisonment of up to 5 years. Acting as a broker or sales associate without being the holder of a valid and current active license. Fraudulent activities. Concealment. Concealment occurs when a broker fails to disclose information to a party, to whom the broker has such a duty, and that is material to his or her decision. Culpable negligence. Culpable negligence occurs if a broker operates in a reckless, careless, and excessively negligent manner. Culpable negligence is negligence for which one can be held legally accountable. A sales associate who forgets to collect an escrow deposit, as specified in a sales contract, may be charged with culpable negligence. Misrepresentation. Misrepresentation is the misstatement or omission of facts. If a question relating to the title of property arises, a broker is required by law to advise a prospective purchaser to obtain title insurance or to insist upon or procure an abstract and obtain an attorney's title opinion. Using lotteries. Contests where no purchase is required may be permissible. Administrative. Administrative fines may be imposed by the Commission for violations of law or rules in amounts up to $5,000 per offense. Step 1. Complaint. A legally sufficient complaint is one that alleges a violation of law or rule has occurred and contains sufficient supporting evidence. The division must investigate legally sufficient complaints. The administrative law judge can issue subpoenas for witnesses and compel attendance of a witness. A respondent may request that an administrative law judge subpoena a witness. The final order panel of the Commission is composed of all members except those who served in the probable cause finding. The Commission reviews the administrative law judge's recommended order together with any exceptions. Step 7. Judicial review, appeal process. If the licensee does not agree with the final order of the Commission, a petition for review may be filed with the Florida District Court of Appeals within 30 days of the final order. The recovery fund is maintained by fees and fines paid by licensees. If a licensee acted in the capacity of a buyer or seller only, the licensee would be eligible to collect following the same procedures as any other member of the public. Chapter 7. Civil Rights Act of 1866, Race Only. The Federal Fair Housing Act is officially titled the Civil Rights Act of 1968. Blockbusting consists of inducing an owner to list or sell on the basis that the neighborhood is deteriorating or becoming transitional due to an influx of minority persons. Steering or channeling an individual, directly or indirectly, into or away from a neighborhood or location in a multi-unit building on the basis of race, color, religion, sex, or national origin. Redlining is the refusal by a lender to approve a mortgage loan based on a property being located in a certain geographical area, the age of the property, the income level of the residents, or the racial composition of the area. Americans with Disabilities Act, ADA. The American with Disabilities Act, ADA, was passed in 1990 with the purpose of providing the same employment opportunities to qualified individuals with disabilities that are available to persons without disabilities. It also provides access for all such persons to public buildings. Owners of properties open to the public are required to remove barriers that limit access or utility to individuals with disabilities. For existing properties that do not comply with the ADA, the owners are required to make necessary modifications whenever such changes are readily achievable and economically feasible, which means easy to accomplish without much difficulty or expense. The landlord options and procedures for handling the security deposit money and advance rent are as follows. Hold the total amount of the security deposit or advance rent in a non-interest-bearing escrow account in Florida. Hold the total amount of the security deposit or advance rent in an interest-bearing escrow account in Florida. Post a surety bond with the clerk of the circuit court in the county in which the dwelling unit is located. A licensee may call an owner whose name appears on a do not call list when representing a buyer interested in buying the property but may not use the showing in an attempt to obtain a listing. Chapter 8. Real property. Real property includes the physical land and improvements, real estate, together with legal rights to own or use the property. Riparian rights. Riparian rights are the rights of an owner whose property borders a flowing waterway such as a river or stream. Accretion. Accretion is an increase in land area as moving water deposits soil in other than its original location. This is the opposite of erosion. Memory device, IRMA. Intent. Relationship. Method of annexation. Adaptation. Legal rights in property. Possession, disposition, enjoyment. Possession. An owner has a right to possess or occupy the property. Disposition. An owner generally has the right to sell the property, to give it away, or leave it in a will. There are exceptions as will be discussed later. Enjoyment. An owner has the right to quiet use and enjoyment of the property without disturbance by hostile claimants. Estate in severalty. An estate in severalty is sole ownership of the entire bundle of rights. A tenancy in common ownership can be created by the same or different deeds, at the same or different times, with equal or unequal shares of ownership. A tenancy in common owner may leave his or her interest in a will. If the owner dies intestate, the interest will descend to the owner's heirs. Joint tenancy, joint estate. A joint tenancy. Possession, interest, time, and title are present. Tenancy by the entireties. Tenancy by the entireties is an estate for a husband and wife only. The marriage is considered to be the owner of the property in which each spouse has a right of survivorship. In the event of a divorce, the ownership converts to a tenancy in common, unless otherwise dictated by a court. Property owned in one spouse's name before the marriage or acquired by gift or inheritance during the marriage is considered separate property. Life estate. The party who created the life estate, called the grantor, may wish to have the property ownership returned to him or her or to his or her heirs. The right to regain the ownership is called a reversion estate. Tenancy at will. A tenancy at will is a non-freehold estate with the tenant in lawful possession of the property under an agreement with the landlord, but with no definite time limit for the rights to terminate. Tenancy for years. A tenancy for years is a non-freehold estate with the tenant in lawful possession of the property under an agreement with the landlord for a specified period of time. Elective share provides for a surviving spouse to be entitled to 30% of the decedent's real and personal property owned at the time of death. The purpose of elective share is to prevent a spouse from being harmed by an unfair will. If a decedent left less than 30% to his or her spouse, the surviving spouse can use this right to override the will and claim at least that amount. The Florida Constitution exempts homestead property from the execution and forced sale of the property to satisfy personal judgment liens, such as personal loans or credit card debt, which are held against the head of a household. However, homestead property can be foreclosed upon for debts that are related to the property and debts entered into jointly by both spouses. If the homestead were owned as separate property of the decedent, the surviving spouse is entitled to a life estate. However, if there are lineal descendants, they become vested remaindermen. The homestead rules override any attempted disposition in a will. Condominiums, cooperatives, and timeshares are all considered to be real estate. Therefore, a real estate license is required to sell or lease these types of properties unless the individual works directly for the owner-developer and is paid a salary. Chapter 9. Constructive Notice. Recording documents in the public records. CRAP, constructive, recorded, actual, possession. Voluntary alienation equals will. Involuntary alienation. Cheated by the state, escheat. Eminent domain. Adverse possession. Requirements for a valid deed include the following. A granting clause or words of conveyance must be included. The deed must be signed by the grantor and witnessed by 2 persons. The grantee is not required to sign the deed. Habendum, clause. The habendum clause, which is also called the to have and to hold clause, specifies the legal rights being conveyed. Quitclaim deed. A quitclaim deed contains no warrants of any kind. The grantor does not promise to have any rights in the property, but rather, any rights he or she may have are being conveyed. To clear cut on title, Quitclaim deeds are most frequently used to cure defects in title. The general warranty deed is the most common type of deed, and provides the best protection to the grantee of any deed. Eminent domain. Eminent domain allows local, state, or federal government, railroads, public utilities, and public housing authorities to obtain ownership to private property. This is called taking. The taking must only be for a public use, such as to build highways, schools, railroads, or public projects. The owner may negotiate with the condemning authority and may even reach an acceptable price. This action to enforce the sale is called a condemnation proceeding. Gross lease. A gross lease is defined as a lease in which the tenant agrees to pay a fixed rental amount, and the landlord pays all expenses related to the property such as real estate taxes, insurance, and maintenance costs. Net lease. A net lease is defined as a lease in which the tenant pays a fixed rent plus all or a portion of the operating costs such as real estate taxes, insurance, and maintenance. Percentage lease. A percentage lease is defined as a lease in which the tenant pays a monthly base rent plus a percentage of the annual or monthly gross sales. A lien may be specific to one property equals mortgage and construction. A superior lien takes precedence over all other types of liens. If a foreclosure sale occurs, a superior lien is paid from the proceeds of the sale before any junior lien. Real estate property taxes. Front of the line. Special assessment lien. Specific lien, a special assessment lien for improvements, such as road paving, sidewalks, and sewers. Chapter 10. The surveyor's method, also known as the metes and bounds method, is the oldest method of land description and provides the most accurate type of legal description. Metes equals distance. Bounds equals angle. Point of beginning. It is where it starts. The survey begins by giving directions from the monument to the edge of the property, which is called the point of beginning, POB. North 37th east equals south 37th west. Township. A township is 6 miles square and contains 36 square miles. Each section is 1 square mile, or 640 acres. As illustrated in Diagram 1, when a section is subdivided into quarters, each resulting subsection contains 160 acres, 1/4 of 640 acres. Plat method. The plat, or recorded plat, method, also known as the lot and block method, is a method of legal description used to identify small parcels of property in subdivided areas and cities. An assessor's parcel number, APN, is a number that is assigned to a parcel of real property by a county property assessor to uniquely identify that property within the jurisdiction. 1 acre contains 43,560 square feet. One section contains 640 acres. Chapter 11. Executory contract. Still in progress, remains to be performed. Void contract. A contract that is void is inherently unenforceable. A void contract cannot be performed under the law. Termination of offers. Acceptance. Withdrawal. Rejection or counteroffer. Acceptance. An offer accepted by the parties becomes a contract. Withdrawal. The offerer can withdraw an offer at any time up to the time that acceptance of the offer has been communicated. If the offerer has received valuable consideration in return for keeping the offer open for a period of time, the offer may not be withdrawn during that time. Rejection or counteroffer. An offer is terminated if the offeree rejects the offer. A counteroffer is considered to be a rejection of an offer. Note: novation does not end the offers. The 3 basic remedies for a breach of contract. Sued for specific performance. Ask a judge to interfere. The party who is not in default asks the court to require the other party to perform as agreed in the contract. Types of damages. Liquidated damages. This usually involves the seller retaining the deposit in the event of a buyer default. Unliquidated damages equals compensatory. The assignor of a contract is not relieved of performance as a result of assignment. Sellers of residential property in Florida are required to disclose any material defects. The use of an as-is provision in a contract does not relieve the seller of this responsibility. Exclusive right of sale listing. Whoever he sales to, I make a commission. The exclusive right of sale listing is a bilateral contract in which the property owner promises to pay a commission regardless of who sells the listed property. The exclusive right of sale contract gives the broker the best protection of the three types of residential listing contracts. To convert this into a listing price, the sales associate would first add an approximate amount to the net required by the owner to cover closing costs. The sum of these two numbers would be divided by 100% minus the commission rate required by the broker. An option contract is a right to buy a property during a specified period of time, at a specified price. The contract for deed is also known as installment sale contract. The agreement calls for the title to be conveyed after the full purchase price, or a stipulated portion of the price, has been paid. Chapter 12. Lien theory of mortgages. Florida is a lien theory state. Lien theory allows the borrower to retain the ownership of the property during the loan period. Note: borrower gets the deed at the closing. Promissory note. IOU. The note is evidence of a personal debt, and contains the names of the parties, the rate of interest, the amount of money borrowed, and the loan repayment terms. Mortgagor equals given the mortgage. The lender equals the mortgagee equals owns the property. The mortgagor owns the real property, while the mortgagee. Satisfaction of mortgage. When a loan has been paid in full in a lien theory state, the mortgagor should receive a letter of satisfaction from the mortgagee within 60 days of the loan payoff. The defeasance clause holds the lender's rights in check as long as the borrower performs as agreed in the note and mortgage. The escalation note, rate can go up, or escalator clause allows a lender to increase the interest rate based on the occurrence of an event. Exculpatory clause. Note: not responsible. The exculpatory clause limits the lender's rights in a foreclosure to the amount received from the sale of the foreclosed property. If the balance of the promissory note has not been paid in full from the proceeds of the sale, the lender cannot obtain a deficiency judgment for the unsatisfied amount. The rule of thumb is that for each point charged upfront by the lender, the rate of interest increases approximately 1/8%. Step 1 to 4 points times 1/8% equals 4/8%, 0.5% or 0.50, increased interest rate. Step 2 to 5.75% discounted rate of the loan, 5 3/4%, plus 0.50% estimated increase in rate due to points paid, 0.5%. 6.25% effective yield, 6 1/4%. The Equal Credit Opportunity Act, ECOA, requires lenders to judge every loan applicant on the basis of the applicant's own credit rating and income. Lenders cannot discriminate against borrowers on the basis of race, color, religion, national origin, sex, marital status, age, or receipt of income from public assistance programs. The process of qualifying the applicant and the property is called mortgage underwriting. Qualifying the applicant. An applicant is evaluated by using the following three criteria: credit history, income, other assets, housing expense ratio. Formula: monthly PITI payment divided by monthly gross income equals housing expense ratio. FHA. To qualify for an FHA loan, a borrower must not exceed a housing expense ratio of 31% and a total obligations ratio of 43%. Loan-to-value ratio. Loan amount divided by purchase price or appraised value equal LVT ratio. Also on notes, loan amount divided by LTV equals purchase price. Or loan divided by LTV equals purchase price. Default. Against the borrower for payment of the debt. Equity of redemption. Means paid in full. Equity of redemption is the right of a borrower to cure the default before foreclosure rather than lose the property. The borrower must pay the entire balance of the debt plus any interest and costs that has accrued since the default. Equity of redemption exists in Florida up to the moment of foreclosure. If all lien holders have been paid from the proceeds of the foreclosure sale, any surplus funds remaining are paid to the mortgagor. Chapter 13. The FHA does not make loans. Instead, it insures loans made by approved local lenders. Maximum loan amount. HUD limits the maximum FHA insured mortgage loan amounts, which vary by geographic location. Prepayment. FHA insured mortgage loans must provide the borrower with the right of prepayment without penalty. VA guaranteed loans. For owner-occupied residences. Eligibility. A veteran's eligibility for the mortgage loan program is shown on a certificate of eligibility that is obtained from the VA. A veteran must serve a specified minimum amount of time to be eligible and be honorably discharged. Private mortgage insurance, PMI. Federal lending regulators usually require this insurance when the loan amount exceeds 80% of the value of the property. With PMI, a conventional borrower may obtain a loan up to 95% of the value of the property. Amortizing loan payments. I equals P times R times T. Negative amortization due to payment cap, goes up. The Federal Reserve Board of Governors has the following three tools at its disposal to assist in the regulation of the money supply or to influence interest rates. Biweekly mortgage, 1/2 every 2 weeks. Making 13 monthly payments each year. Discount rate. Works the least effective. Since this affects only a small portion of the banking system, changes in the discount rate are considered to be the least effective of the Federal Reserve's three tools. The primary mortgage market is where loans are originated. Life insurance companies are the largest source of funds for financing both apartment projects and commercial properties. The secondary mortgage market does not lend money. This market consists of secondary market lenders who purchase mortgages that originated in the primary mortgage market. The principal secondary lenders are governmental or quasi-governmental agencies and include the following organizations: Federal National Mortgage Association, FNMA or Fannie Mae. Federal Home Loan Mortgage Corporation, FHLMC or Freddie Mac. Government National Mortgage Association, GNMA or Ginnie Mae. Ginnie Mae is primarily engaged in purchasing federally subsidized residential mortgages that are originated by local lenders. Real Estate Settlement Procedures Act, RESPA. Settlement closing. Requiring lenders to provide a loan estimate of settlement costs. Requiring each loan applicant to be provided with the information booklet titled Your Home Loan Toolkit, which explains the various closing charges. Requiring a mortgage servicing disclosure statement that discloses to the borrower whether the lender intends to service the loan or transfer it to another lender. Truth in Lending Act. Regulation Z. Residential borrowers be clearly shown the cost of credit in both dollars and percentages. The percentage is stated as an annual percentage rate, APR. Triggering terms. The triggering terms are: amount of the down payment, expressed either as a percentage or as a dollar amount. Amount of any payment, expressed either amount. Amount of any finance charge. Chapter 14. Binder deposit. The buyer paid the binder, or earnest money deposit. The broker usually holds this earnest money deposit in an escrow account until the day of closing. On the closing statement, it is entered as a credit to the buyer since this portion of the purchase price has already been paid and will not have to be paid. Items subject to proration include mortgage interest when a loan is being assumed, real estate taxes, insurance, and rent. Example, calculating a rent proration. $300 rent per month divided by 30 days in the month of April equals $10 daily rent. PMM means credit to seller debt to the buyer. Prorating property taxes. Step 1. Calculate the number of days the seller has owned the property. Step 2. Calculate the daily tax amount. Step 3. Calculate the amount of property tax owed by the seller. Entries: $203.18 debit to seller, $203.18 credit to buyer. Expenses are debited to either the buyer or seller. There are no credits in this section. Note: expenses are always debit. The seller is normally expected to provide either title insurance or an abstract accompanied by an opinion of title as evidence of a marketable title. Currently, the tax on the deed is calculated at the rate of $0.70 per $100 of value, or fractional part thereof, based on the sales price of the property. Step 1. Calculate the tax units. $80,000 purchase price divided by $100 equals 800 tax units. Step 2. If the results contain a decimal, the number of tax units is rounded up to the next higher whole number. Step 3. Calculate the state documentary tax on the deed. The state documentary stamp tax on a promissory note is calculated at the rate of 35 cents per $100 or fractional part thereof on the total amount of the note. The state documentary stamp tax on the note is paid on both new and assumed notes. The state intangible tax on mortgages is paid on all new mortgages only. The state intangible tax on a mortgage is calculated at the rate of 2 mils, 0.002, on the total amount of a new mortgage. The tax is not payable when a mortgage is being assumed or title to the property is taken subject to the mortgage.